Hi, I'm Greg Dell, joined by attorney Stephen Jessup, and we're going to discuss how to win a Unum disability appeal. And Stephen, you've reviewed thousands of Unum disability denials. I would say that you know basically everything there is to know about Unum, from litigating against them, from seeing their internal claims handling manuals, from deposing their people, from every gamut of what could be done about Unum, and also considering that we probably get more calls than anyone else in the country from Unum, we're constantly in the know of what's going on with Unum, because if they're onto a new technique, we get it, because in any given week we'll get 40 calls from people saying, this is what Unum did to me this week. We see the same characters, and I call them characters. They're doctors, they're claims people, they're supervisors, they're vice presidents, whoever it is that have been with the company for a long time, so we know exactly how to deal with them. But there's so much that goes into how to win a Unum disability appeal, and when people call you, they'll basically say, do you think I can win? But what is it that you're immediately, thinking about and need to know in order to determine, can they win this appeal?
I think first and foremost we need the policy, we need the denial letter, before we can really give it an idea of what we can do. Other than that, I want to know what the medical condition is and doctor support. Usually in that initial call you can gather a lot of information about that, because unfortunately, we see is not always the best doctor support, and that is a huge handicap in any Unum case.
Okay, so first thing I asked you about was for someone who's calling, because people are watching this video or seeing us for the first time and they're thinking about, do I need help, do I not need help? But in terms of how to win the appeal, it's a super broad question, but why is it so broad? Why is there not just one formula for how to win an appeal if you've been denied?
Even though we can see trends with an insurance company and the way they do things, every case is so individual to the condition, the occupation, so there's always nuance there, and it's very broad and very fact-specific to the person. So there might be overarching themes that we may want to look for, but to really have a chance of winning, it's really as individual as the person that's calling.
Okay, so someone's going to call you, and if you're interested in the case and you think you can help them, you'll basically get a general flavor based upon the policy and the denial letter. But then, as everyone will learn in their denial letter, because some people call us, they don't even have the denial letter yet. But if they do have it, it says you're entitled to your claim file in there. And I want you to talk about why that's so important and how that shapes the plan of attack that you're going to put into. And just talk about the claim file and how now you get that and how you can formulate your plan to determine if you really can win this appeal.
Yeah, and if you watch any of the videos, you talk about all the downsides of ERISA, the area of the law, but one of the positives is in the denial they do have to give you the claim file, and that's everything. Anything you've ever submitted or they've ever created as part of the claim, so they can't hold anything back. In other areas, you got to wait till you're in litigation before you can get everything. Here, they give you everything. So you're able to process what were their internal notes between their employees as to issues they saw in it, what their doctor's opinions were about lack of information or not believing certain information, what the vocational people were saying, and even did they have all your records, right? So you can't take at face value. They said they have things, they may only have portions of it. So the claim file gives you everything, so then you're able to dissect and figure out, all right, well, these are the problems they're identifying. How can we address these problems to show the support for the disability?
Now, specific to Unum in terms of winning an appeal, we know that Unum is the biggest disability company in the world, and with that they try to streamline a process because they have so many claims handling people, so many claims to get through. So they try to, and they do a pretty good job of maintaining their claim file and their records in the same manner. So every time we get one, it's basically we know how to attack it, although they tend to bunch a lot of stuff together, but we know how to break out the sections for what's what. And Unum, who has a very notorious, a very negative history from claims handling because they were sanctioned in the past by multiple states and fined millions and millions of dollars and had to review tens of thousands of claims in the past, came up with a regulatory settlement agreement many, many years ago and then implemented new protocols and internal guidelines that they're supposed to follow. And they do follow those guidelines to a certain extent, but we often find that while one person will make the denial, they always go to some kind of
a round
table type meeting, which I find to be relatively disingenuous because now they get together with
It's confirmation bias.
I mean, they get together with the claim person, they get together with possibly a nurse or an internal doctor, they get together with a vocational person, and then they're always some kind of supervisor based upon the threshold of how much is at stake. And these 4 or 3 or 5 people are not sitting around saying, so let's look at this file today of so-and-so and what evidence do we have here to support disability? I believe they get around the table and they look at this and go, so what evidence do we have here to not support disability? Not the same way that I see it with every carrier, and I don't know that every single carrier does this roundtable thing, but they'll get together, they'll make a plan. It's usually, you're all there with the supervisor, so it's always driven by the supervisor. And you always see that one line like in the SOAP notes, which is SOAP notes are those the records of what everyone's done in there, giving some kind of direction. Well, none of them disagree or speak up. They're just doing what they're told. They're like rank and file officers in line and say, okay, we're going to execute that particular plan. So they then go to most of the time their own internal doctors. And so, you see everything they're doing and they're trying to say, well, we're following our regulatory agreement. And then they'll make a decision and they'll go to another, what do they call it, the DMO?
Yeah, designated medical officer.
And the medical officer, 99 out of 100 times goes, yeah, I agree.
Rubber stamp.
I agree with what that doctor said, that's reasonable. And they do like a 3-sentence thing when they've been asked to review hundreds, if not thousands of pages of medical records. So, just setting a background, because we understand completely where everyone's at. They've got this denial letter, but they may not know in watching this video that, oh, there's this whole claim file. So we're going to get that. So how then do you shape your plan of attack to win this disability denial?
Usually I'm already even starting to do that in the denial letter, understanding what needs to be done. And then that is just then refining, what exactly should be done within it. Going on that group review, to me, it's groupthink, right? One person comes up with an idea and everyone comes, has a meeting of the minds to figure out how to support that opinion for the denial. So it is the dissection of that. And that's why, doctor support is so important, and what your doctors are putting in their records. Normally when someone contacts a claim has been denied, I would say it's not, well, maybe more often than not, that the records aren't that great. They're not very, detailed with regards to the issue the person's having, complaints, things of that nature. So it's always thinking about what's the condition, right? If, just taking, for instance, a physical condition, person has complaints of pain, inability to sit, get through the physical aspect of work. Well, what type of objective testing can we find to support those subjective complaints? Work simulation exams, functional capacity examinations, which by no means perfect science, because nothing is going to replicate what your job does, but you have to keep in mind that those claims people at Unum, they're looking at your occupation and your abilities according to Department of Labor physical standards more than anything. So many times in the denial letter, you can do sedentary work. Your job was sedentary, so you must be able to do it. So how do we then prove with the standardized tests that that's not the case? Complaints of inability of focus, memory issues, some level of cognitive testing. What can we do to really build up objectivity to what they're always going to argue are subjective complaints? And then one of the more important aspects of that as well is that most, well, not most, but I'd say a good number of policies you're going to see from Unum, they have a 24-month limitation for mental health, which is standard, meaning after 24 months they have to pay you. But they also have one called their 24-month self-reported symptom limitation. And that usually reads something like the manifestations of your conditions that can't be verified by testing, to include pain, fatigue, ringing in the ears, headaches, things like that. So there's really the risk that you could win the battle of getting approved, but lose the war because you pigeonhole yourself into that. So what additional objective evidence can we put into this to avoid some of those things that, as an individual, they're saying, might not be thinking about, oh, I have to prove this for down the road, but what we can do to set you up for future success. What the difference if there's a change in that occupation from own to any occupation. So it's a matter of just constant refining and refining and refining till you really get to the heart of what's most important. That idea of, 80% of your results will come from 20% of the work. So focusing on those big things that is going to carry over, give you the most compelling evidence.
Right, and another strategy is, one of the ways I like to do it in terms of winning an appeal is I like to work backwards, but it's different as us being lawyers versus someone who may try to do their appeal on their own, because I'll read the denial letter, I'll read the claim file, I'll see everything. Then I'm thinking in my mind about what have they done wrong already? But then I start to say to myself, you know what, this is the appeal. It's almost kind of irrelevant what they did. I need to win this thing on the facts. And that's along the lines of what you were saying. How much objective evidence can I get in here to say that supports on paper that you can't do everything that you say you're doing? How many doctors, how many medical opinions can I get? How many articles can I get? How many other experts can I get to support your position that shows that you can't do your job? How clearly am I just explaining to them what the duties of your occupation are? Or if it's in any occupation, why you can't do any job out there, and what experience, education, and training do you do? Because it's not just about your ability to go work at Burger King and flip burgers or something like that. It's really based upon your experience, education, and training. Could you do the job that Unum suggested that you could do in order to support their position that you could go back to work? And so, you know, you take all of those things in a totality and you try to put together this super, super strong appeal, thinking that who's going to review it? Who's the next person to see this? Because that is one nice thing about ERISA. We're going to get a new person. It's still a person at the company. But how do I make this appeal so strong that no reasonable person, including I want to win the appeal, I don't want to lose the appeal and have to file a lawsuit? Because it's on one hand to think about what a judge is going to say, but a judge is a reasonable human being in most cases, is supposed to be. But how can I convince this claim person right here? And not only that, I often say that the claim person is just a paper facilitator who's going to gather everything we submit and then give it out to their medical team or their vocational experts or their director, and then just like, here's my job to sort it all for you. You come back and tell me whatever the doctor says I'm going to adopt. So in a way, with our appeals, when we gather evidence, I'm talking to their doctor. And I'm thinking like that doctor. I'm thinking, how could I give the evidence to this doctor where no doctor could look at this and go, no, they don't have any restrictions, limitations. And you have to know how to present that evidence and get that evidence from the treating doctors, from functional capacity testing, from work study analysis, from some of the tools. There's so many tools out there to do that. And claimants have to know how to do that. That's what we do, and that's what we love to help claimants to get that evidence there. So first make the claims person say, gosh, I can't disagree with this. Then really push their doctor, because you know their doctor is going to get it, and hopefully their doctor won't. That's how you win this. You also write the appeal, because we've done other videos about how to write an appeal. That's a whole nother art, because you can't tell Unum every single thing they did wrong, because then if they address every single one of your concerns,
you have no
even
arguments.
if they're dead freaking wrong, then when you go to file a lawsuit, it's hard to say they acted unreasonably. Even though they came to a completely wrong decision, it's hard to say they acted unreasonably. So it's an art to writing this appeal, and that's a whole nother animal. Once you gather all your evidence, then what's the art of writing it such that you tell them what they need to know, but you don't cut off your arguments to go to court. And that's the, that's the biggest challenge that we have. That's the art that over the past, you handling thousands of claims, that you've begun to master in such a way that you win the majority, high majority of your appeals, because we put the evidence in front of them in such a manner where we can win. So, it's frustrating. Yeah. We understand. Frustrating for us because we see poor denials often from Unum, and it's just because because there's no consequences under the ERISA laws. But feel good about being able to help people and that there is opportunity. The claimants should absolutely feel opportunity. Once we get that denial letter, look at the policy, give them a glimmer of hope to say, yeah, I think we can win this. It's going to take a little bit of time, but if you follow our plan, we can get you there. So it's a wonderful thing that we're able to do, and not feel intimidated by this billion-dollar company that you're not going to win, because you can win.
Yeah,
so.
And I always tell anyone that calls, you've got nothing to lose in fighting and pursuing. Worst case scenario, you're exactly where you are. Because when people are disheartened and want to walk away, just continue to fight, and continue to present the information. So, it's a very personal thing for them, and I always try to tell any potential, don't take it personal in the sense this is how they act, this is what they do. So, understanding what they're going to do then allows you to set up to look about what you can do to, win your case.
Right, and we'll give them the exact roadmap and guide. Here, you have to do this, this, and that. And if you do all of those things, then you're going to be in the best location, the best chance possible to win your appeal. So if you're someone out there with a Unum denial, feel free to call Stephen or myself. No matter where you live in the country, we're available to assist you, and we look forward to providing you with a free consultation to discuss how we can win your Unum disability denial.